or health of the pregnant individual. The state will not be able to penalize any person for aiding or assisting a pregnant individual in exercising the right to an abortion. On your ballot, you will also see an area for no vote for Proposition 139. So a no vote for Proposition 139 shall have the effect of not creating a fundamental right to an abortion under Arizona's Constitution. It will leave in place current laws that restrict abortion before fetal viability and will allow the state to further restrict or ban abortion in the future. So at this time, I will ask the opponent for Proposition 139 to come up and speak for 40 minutes because we don't have a speaker for Proposition 139. So we'll only have one speaker today for Proposition 139.
Well, hi, I'm Cindy. Thank you, Renata, and the Secretary of State's office for giving us the opportunity to come out here and talk about Proposition 139, a much more extreme amendment than what you just heard them read. It's very interesting, the language that they have used, and if you're interested afterwards, we have gone through that language and pointed out just a couple of problems. The other side, the proponents of Prop 139 are not here today. They refused to debate us 3 times already so far, and they have refused to take your questions, any voter questions, 3 times so far. And that is the town halls here like this one. There are 3 of them throughout the state that the Secretary of State's office that puts on, invites both sides, and we show up at all of them because we want to make sure that voters are informed of exactly what is in this amendment and to answer any of their questions because it can be very confusing. When proponents talk about this amendment, they speak on this very high level, very vague, speak in generalities about it. And they don't want to talk about the specifics because that's where the dangers are. Those specifics, those details in this amendment, those are the things that pose the risk for girls and women and the fetus when it can survive outside the womb and frankly beforehand. So when you hear, to hear proponents or even the news media for that matter talk about this amendment, you would think that it has limits and that a doctor is involved and that safety precautions will be in place and that there is a ban right now. All of that is false. There is no ban in Arizona. Whether you support it or not, abortion is legal in Arizona up to 15 weeks and beyond that for any medical emergency. And Arizona's Attorney General Chris Mays spoke about this a couple of months ago, and she said that exemption for medical emergency is very broad. It's going to cover a lot of things that the other side was saying it wouldn't cover. Still, that did not stop the proponents from dropping an ad last week, I think it was. They started off saying, pass Prop 139 to stop the ban on abortion. Of course, not true. Then it went on to tell a story of how girls are and women are dying in the emergency room and suffering in the emergency room with miscarriages because they won't get treatment for miscarriages. That is not true. They also said that doctors won't treat women who are suffering miscarriages because they're afraid of going to jail. That's not true. And if you'll note, that was all B-roll and all a hypothetical situation because they could not find one example here in Arizona of that happening, or anywhere for that matter, because in all 50 states, there is no law against treating a woman for miscarriage or an ectopic pregnancy. As a matter of fact, under Arizona law, it's, I think, 362151, it specifically states that treatment for miscarriages and ectopic pregnancies are protected, and they are not even, they're actually excluded from the definition of abortion under Arizona law. If that wasn't enough, Arizona Attorney General Chris Mays, again in that same memo in June, talked about how she cited that law and said doctors don't have to worry about anything. They don't have to meet that standard of medical emergency or anything. They are clear to treat women, and women are guaranteed to have that treatment for miscarriages and ectopic pregnancy. So even though she said that in June, proponents came out 2.5 months later with this ad, and they go forward with it. So not only that, but they put that information out there to voters. And was that 4 minutes already? I have so much more to say. Okay, so I didn't get to very much, so ask questions. Okay.
Okay. And you?
I have a question to the Are we asking questions to the comment, or who are we asking questions?
Well, you're just asking questions in general, because if one should just ask those questions in general and not specifically designated to her. It's like myself and our policy director will try our best unless. I mean, if you definitely, if you have an answer to it, but we don't want it just one sided, like one person each contract.
I understand that. I want to know what happens since this, right now, the statute, the 15-week statute, it can be changed by the legislature, is that right? And then the next thing would be, what if we go back to having an attorney general or county attorneys who are not willing to protect the rights of women and girls over their bodily autonomy? So when the constitutional amendment protect women and girls in Arizona, where the statute can be changed and its enforcement can be changed.
Okay, so you're asking about the statutory context of the law now, correct? And its effectiveness. I guess I'll just go to, if there's a constitutional amendment, it will supersede any statutory changes.
I think you can hear me.
No, use the microphone.
My question really goes to the the opponent of the measure was talking about how our Attorney General has interpreted the statute. And so I guess really what I want to hear is the distinction between a constitutional amendment and the statutory schemes that exist now, and how the Attorney General of Arizona and, for instance, the Pima County Attorney have made statements that they're going to interpret the statute in a way that protects the rights of women and girls who are pregnant to their bodily autonomy, and doctors and women will be prosecuted. And then you have the constitutional amendment, which would enshrine that, so you wouldn't vacillate with the any change in the Attorney General's office or in the Chief Law Enforcement Office.
Well, thank you for the question, and I'll just back up. My name is Colleen Connor. I'm the Policy Director for the Secretary of State's office. I'm also a counsel to the Secretary of State. So, Renata Fisher and I are very familiar with the initiative process and how the Secretary of State's office processes petitions, and the lovely publicity pamphlet is issued, and all the duties of the Secretary of State, and how we are required to put on these town halls, and happy to do so. As far as your questions that get into the very detailed issues of the statutory scheme related to abortion, I don't have an answer for you. I just don't know. Okay.
Thank you. If I understand your question right, I would say under Prop 139, any constitutional amendment, any ballot measure that is passed by the citizens cannot be touched by the legislature. They cannot make any fixes to it. So if we find out that what we're saying about the language, that you'll lose the doctor, you'll lose the very basic common sense safety precautions that are in place now to protect girls and women who do get abortions. If it turns out that voters realize that this enshrines abortion through all 9 months of pregnancy, and they wanted limitations on it, they will not be able to lobby their elected officials to change the law. Their hands are tied, they can do nothing because of the Voter Protection Act. Does that answer your question? Yes.
The gentleman with the tan shirt, I saw his head, and then I saw the gentleman with the white shirt, glasses on. You're next. See you.
My name is Myron Smith.
aside from the merits or perhaps demerits of this proposition, I would like to know, in God's green earth, the language used instead of women, pregnant women, the term pregnant individual is used at least twice in this proposition, which speaks to me of an umbrella of falsity surrounding this issue. Thank you.
Hello, my name is Tony. How does the state define healthcare professional? Doesn't that include nurses, nurse practitioners, chiropractors? Aren't those healthcare professionals?
I believe it, there's probably a statute on it, it is not provided in this initiative, so we're not familiar with it. Sir, I'm sorry, but we're not an expert in this area. Okay.
Thank you. I'm familiar with that statute. You're correct. It does not define what that term is. As a matter of fact, there are a lot of terms in this proposition that are not defined. So when a court looks at that, and they look at the proposition, and they say, oh, okay, any healthcare professional, and they see that it's not defined, they will go to Arizona law to see if it is defined there. And it is defined in Arizona law. And there's a list of 25 professions, all very respectable professions, but not all of them know anything about abortion or caring for the woman or the girl afterwards or anything like that. And I heard some of the things that were stated, and that's exactly correct. It is, it goes beyond nurses. It could be, the school nurse. It could be
Doula?
physician's assistants, but it does include podiatrists and chiropractors and massage therapists and veterinarians and a whole list of other statutes. So it opens that door very wide. And if proponents were here, we could ask them why they did not define it and why they opened that door so wide if it's so ridiculous to think that a podiatrist would do it.
Gentleman in the red shirt. Yes.
Yeah, Cindy, to comment on what the gentleman in front commented about the wording regarding minors getting abortion without parental consent. Thank you.
Quick, okay. Yes, we use the term individual. It may be there for other reasons, but it specifically means legally that any minor. There is no minimum age limit on this. In Arizona, the law is that any minor who gets an abortion has to get parental consent or a judicial bypass. Under this amendment, that goes away, and a 15-year-old girl can order the abortion pill through the mail, take it on her own, never be examined, never see a doctor, have no medical oversight, no parental oversight, take it by herself, and be bleeding and in pain for hours, not know when she's in trouble, when she's hemorrhaging, and it is basically a modern-day back alley abortion.
Let me go to someone else because I want to make sure that everyone is heard. The lady in the red shirt. Yes.
Thank you. My name is Maria. I have a question about not seeing anything in the law that speaks to, it seems to protect people that are helping someone get an abortion. I'm not seeing how that would protect an individual that's being trafficked or that has been raped and is being dragged into Planned Parenthood, and potentially there's no protection for that individual, nor is there prosecution capabilities for the individual that is causing the harm.
Well, I will just add, there is another initiative regarding child sex trafficking. I don't know how it would interact with this. Yes, 139 does not address any of the issues. The lady in the back. It does? Excuse me.
Okay, yes, correct. Under Prop 139, it says that anyone who brings a woman or a girl to get an abortion cannot be prosecuted for bringing them in. It does not specify who that is, it doesn't exclude anyone, so it does include a sex abuser who takes his victim to the abortion clinic to cover his crime. He will not be prosecuted for that cover-up, and then of course it makes it harder for him to be prosecuted for that crime. And we know someone here in Tucson who went through that, and because nothing was done about it, that abuser went on to abuse her for 9 more months. Yes, of course.
Are there any more questions or comments?
So I think it says a healthcare professional in their good faith
Microphone, please.
I believe it says healthcare professional in their good faith judgment can authorize a abortion after fetal viability for almost any reason for a woman to have an abortion. Is that accurate, and what would be some examples of that?
It's hard to answer that in 30 seconds, but okay, I will address that. Yes, the amendment does split up, before viability and after viability, but it's really just words. It really means nothing because there is no limit on abortion in Prop 139 because it says up to viability, but then after that for the mental or physical health of the woman. But then the U.S. Supreme Court has already ruled on what that exemption means, and it is very broad. It includes not just that her health, mental or physical, is in jeopardy, but that she could be stressed or anxious. The Supreme Court said it could have anything to do with her well-being, a very broad word, and so there's really no limitation in truth.
What would be the definition of well-being? An example?
That's a good question. It would be anything. It could be that she's stressed, she feels stressed, she's having second thoughts, she's concerned about her finances, her family situation. Really, there's no way you could set a limit that would stand underneath that kind of language.
The lady in the blue, I saw the gentleman back there with the glasses on, and then I will get to others.
I'm just wondering, right now the law says that a woman has to have an ultrasound before she has an abortion, and then an ultrasound afterwards to make sure everything's out. I'm just wondering if this proposition would change that. I know how important that is.
I can do it briefly. Okay. Yes, as a matter of fact, none of the regulations, or almost none of the regulations, under Arizona law right now would be able to stand under this amendment because of the broad language and because it makes it a constitution, or it makes it a fundamental right, and then it says no regulation can interfere with that, even safety precautions. And so that would include, and we can look at Michigan, we can look at Ohio, that's exactly the language they use there, exactly what happened there. And just earlier this week, the attorney for the components of Prop 139 came out in the Arizona Republic and admitted that the ultrasound would not be able to stand.
Yes. Yes.
I can talk really
Oh,
loud.
I'm sorry.
Sorry.
The gentleman with the
I
glasses.
stood first.
Do you need me to stand?
No.
Thank you. I'm just wondering, are we going to cover the other propositions? We seem to be spending a disproportionate amount of time on this.
2 hours.
We will, I will answer here, because we want to remain respectful and cordial, because at all times, no matter what, that's all I ask, remain respectful. Because everyone has a right to be heard, and so, again, I cannot stress, respect. That is one thing that we all can do, because I want to be respectful of each and every one of you, and I hope that you will do the same. And so, to answer your question today, we will only be discussing 139 and 140. Those were the, and so after we finish Proposition 139, we will move on to Proposition 140.
Good morning. So my question is, so it sounds like you, with the
this new proposition, you'll be able to have an abortion up till birth, correct? So somebody asked me the other day, like, who would do that? Like, why would you ever need an abortion at delivery? And are there any cases that we've ever had that in Arizona, where you've had, at 40 weeks, had an abortion? So, can you answer?
Yes, you're right in saying that this amendment allows abortion through the entire pregnancy. The Guttmacher Institute, they are supporters of abortion. They say that at least 10,000 late-term post-viability abortions happen in the United States every year. And then that same institute says that most of those abortions are done for the same reasons that earlier abortions are done, and on healthy fetuses and healthy women. So yes, it does happen, and it's not necessarily to save her life. I know there is a doctor here that could answer that question. As far as her second part of the question is when. I cannot answer it as a doctor. Can we have the doctor answer that?
Yes.
If he's
Really quickly,
willing.
I need to other questions, but yes, is there a doctor?
Dr. Levatino.
Arizona currently restricts abortions to 15 weeks, and it's been that way for a long time, so there's no one set up to do these late-term abortions that I'm aware of in Arizona today. But just look to New Mexico. There is a clinic there in Albuquerque called Southwest Women's Options that will do abortions all the way up to term. Doesn't matter why you want it, they'll do them. They're $8,000 for a 25-week abortion, $1,000 more for every week after that. And she's correct. Ellen Guttmacher that she's talking about is a research arm of Planned Parenthood. So you know what they're, you know where they stand on the issue. And there's research out there, published papers that will tell you that women having abortions after 20 weeks, by and large, are having them for the same reason that they're having before 20 weeks. And I can tell you that from experience.
And we'll get to you, the leading the white shirt, and then
Yes, a similar term that's quite vague is fetal viability, because that's very dependent on the circumstances surrounding the birth and then also the technology available at the hospital. So I'm wondering if you could address that term and how that would be affected, and why can't the baby just be delivered and not aborted if the baby is already able to survive outside the womb?
So in addition to what I talked about earlier, as far as viability, what the U.S. Supreme Court has said about the exemption that is included in Prop 139, beyond that, Prop 139 says about viability that it could be, quote, dependent or based on the particular circumstances of the case. So that's pretty vague. There's no limitation that could stand underneath that language in a court of law. So there, and what was the other part of your question? Did you have another part of your question to that, or just have that one?
Why can't they just be delivered instead of aborted and killed?
Well, the doctors that I have talked to says that is exactly what they do. In the cases of when they're not looking for an abortion, but there's a serious risk to the woman's health, and the baby if there's a serious risk to the health of the woman, and the babies can survive outside of the womb, they will deliver it.
So my question is very similar to hers. So if this passes, I guess my question is, we know babies feel pain past 12 weeks, as early as we know. We can't know that further right now. But if the abortion doesn't take, I have a friend that's an abortion survivor, is the baby set aside and given comfort care to die? Is it revived? What happens? Do they smother it like some abortionists? Like what will happen under this if the baby survives the abortion?
So under Arizona law, any baby that survives an attempted abortion has to be treated, and then it's defined as to what sort of basic standard care that they have to be given. under Prop 139, it would be argued that that could not stand because it is denying the woman her fundamental right to the abortion.
The lady in the blue shirt is not with.
Okay. My question is, I've actually read the abortion pill prescribing information for mifepristone and misoprostol. And in the indication for those drugs requires a medical doctor to prescribe it, and also says that you need to have a minimum of 3 visits to the doctor because of the risks involved, and also to determine the gestational viability, and also to describe, to determine the date of the age of the fetus, and also to rule out a natural pregnancy, and all of those things. So if this law passes, how will they enforce any of that? And how can a drug be prescribed then if it's out of indication? How is the FDA gonna?
I think that's well beyond the scope of this ballot measure, but Cindy might have some information.
I can answer that. They wouldn't.
They wouldn't.
Current Arizona law requires a medical or surgical abortion must be done by a physician. That goes away with this. Nurse practitioner, nurse, physician's assistant can at least prescribe abortion pill, and that law goes away. Current abortion law requires an ultrasound ahead of time. This is critical because the pill must be used at 10 weeks of gestation or less. If you're on and this will also, by the way, this law will also open telemedicine clinics from out of state and out of country would then become illegal in Arizona when they are not today. And a woman can make a phone call or a video chat and get the abortion pill with no physical exam of any kind. 40% of estimated gestational ages based on last period are wrong, according to ACOG. The American College of Obstetricians and Gynecologists was very pro-abortion. The other thing about it is an ultrasound will give you an accurate gestational age, and it will also rule out an ectopic pregnancy. Ectopic pregnancy can and will kill people getting pills. Parental consent is required. I'm going to talk about that when I get my minute. Abortion providers must have admitting privileges. Again, you get a pill from out of state on a phone call or a video, which is not legal today and will be legal if this thing passes. And when she calls with bleeding or pelvic pain at 2 o'clock in the morning, I'll give you 3 guesses what they're going to tell her. Go to the emergency room. And they won't bother calling the emergency room either. This has been happening again and again and again. Current Arizona law protects women's health in so many ways, the ways I've talked about. They will all go away with this passage.
I don't know if it's a proper question, but I'm going to ask it anyway. I would like to know this gentleman's name and what type of practicing position.
I'm Dr. Anthony Levatino. I'm a board-certified obstetrician gynecologist, and I performed over 1,200 first and second trimester abortions.
Thank you.
Yeah, so on my way in here this morning, I heard a commercial that was pro 139, and it was a couple discussing how they were denied medical help because the baby was not healthy and it was dying. And they were upset that they had to carry that baby. I want to know, does that happen in Arizona? Are women really denied? And how can they lie? Because I know they're not denied. How can they lie in a commercial like that? How many women have been denied their medical help when they are in need of medical? I had a miscarriage. They took me right in and took care of it. I didn't have to wait weeks. So I want to know where we stand on that. Is there any cases in Arizona that they can prove that has happened?
It's not illegal to lie.
That's right.
women in Arizona will get, it is true that women in Arizona will get treatment for miscarriage care and ectopic pregnancy care. And if it is a non-viable pregnancy and they're in a situation where they know it is not going to survive, you can get an abortion for any reason up to almost 4 months in Arizona.
Can you hear me without the microphone? Your patient today is 16 years old. She's 20 weeks pregnant. She's asleep on an operating room table. Her parents have no idea where she is. You do a suction, you take the fluid out from around the baby. Then you use something called a Sofer clamp, and you reach in. Now, how big is her baby at 20 weeks? All the way up to her umbilicus. The length of your hand from the tip of your middle finger to your wrist. That's 20 weeks, not counting the legs. You reach in with the Sofer clamp and blindly grab and pull, and I do mean hard. And out pops a leg this big, which you put down on the table. And do it again, and pull out an arm just as big, and put it on the table. And tear out the spine, the intestines, the heart, the lungs. Head on a baby that size is about the size of a plum. You know you've got it if your instrument's around something, your fingers are spread as far as they'll go. And you know you did it right if you crush down on the instrument of white material runs out of the cervix. That's the baby's brains. Now you can pull out skull pieces. Sometimes a little face comes back and stares back at you. That abortion, absent a medical emergency, is not legal in this state. It will be legal if this passes. And if you get a complication like I did doing abortion sometimes, that's when mom and dad will hear about it. Oh, I'm sorry, we perforated her uterus, she's bleeding heavy, and she needs a hysterectomy. Now we need your permission. That's what this proposal will do. And one last comment, I'm not the least bit surprised that the proponents aren't here. When you've got tens of billions of dollars of outside of state money and tens of thousands of TV ads, why do you have to show up at some stupid town hall?
Are there any other questions or comments from people that we haven't heard from?
Yes, I don't have a question, but I have a comment. The terms zygote and embryo and fetus are often used instead of unborn human, which is actually what they mean. The term zygote is the Greek word for, I believe, a single-celled individual. I know for sure that fetus is the Latin word for little child, person still in the womb. My comment is just why is there such a push to not use the real term unborn human being? And I know there was, where was that? Pardon me, I am not a speaker. And I'm not going to be able to find it. It was about if my memory is serving me correctly, it was about the abortion, Arizona's for Abortion Access had not wanted to have the term unborn human in the language of the proposition and actually sued, and it was actually overturned. So now, in an accompanying pamphlet, from my understanding, the term unborn human being is actually used. It's just a comment, and it's to me, whenever I was a kid, or even now, when I'm a sinner, I tell lies. My children told lies when they were trying to do something bad and hide it. They would use the wrong terminology. And so it's just a comment. Why use the term, why use a Latin term, a Greek term to describe something that we all know is a person? It's just troublesome. So.
Thank you. The gentleman in the turquoise.
Hi, your comment there about the Arizona Abortion Alliance, I looked into that. I was going to see, is this abortion Proposition 139, is this a grassroots effort, or is this something that's outside of this state? Look at all the supporters and where the money is coming from to support Arizona Abortion Alliance who is the voice for this proposition. The top 8 donors are all either unionized organizations, a Soros organization, Planned Parenthood, or ACLU. None of these organizations are Arizona organizations. And we're not the only state they're doing this in. They're doing this in Florida, they're doing it in Colorado. They're sponsoring 10 of these initiatives across 10 different states. And they don't vote here, but they're looking to change our Constitution. And we have no right to change it.
I see you, sorry, I just want to make sure, is there anyone else who has a question or comment?
I just want to make a comment. I don't work in the hospital ICU.
Microphone.
I just want to make a comment. They were saying that Chris Mays has come out about people not getting services. It is against the law for a hospital. I worked as an ICU nurse for 20 years. I worked in the hospital for 31. It is against the law for any hospital to turn anybody away for medical services. So that was a lie, and I'm appalled that our Attorney General would voice that kind of a statement when any healthcare professional that has worked in any hospital, clinic, or doctor's office knows what the law is. They are required to give a medical examination, make sure that person is stabilized. If they cannot provide the care, they can transition them to a level of higher care to another hospital. So I'm very, very disturbed. Why would you feel the need to do that?
I can talk. I would like to know, so a pregnancy that has proceeded beyond viability, that has gone beyond viability, so past the 20-week or 24 weeks is the legal definition of viability, though we have Curtis Mason, who survived at 21 weeks and 1 day, so viability can be much earlier with our modern technology and medication and stuff. So if you have a later term abortion, what does that entail? Is that the partial birth abortion, where they're actually partially delivering the baby and then suctioning out the brain and killing it, which is probably Dr. Levinson. Can you answer that? Exactly. How is a later term abortion done?
Abortions up to 24 weeks, which is the kind of upper limit of viability now. Now it's down to 22. Are done with D&Es the way I described. After that, they typically use induction abortions. Partial birth abortion was made illegal by federal law several years ago, but induction abortions are now being done. This clinic I told you about in Albuquerque is doing them up to 35 weeks for no reason, any reason. You want it, if you can pay for it, they don't care. And they've got them laboring in hotel rooms.
So I can only imagine.
Which will then become legal in Arizona.
Yeah, I can only imagine the mental anguish and guilt that woman will carry for the rest of her life.
They don't care about
doing that. But she will.
That's her problem.
Yes, I'd like to know, under this proposition, will a doctor be able to refuse doing an abortion if it goes against their religious beliefs?
There's nothing in the law that, in this ballot measure, that would compel a doctor to be a healthcare professional in opposition to one's religious beliefs.
Here's a little bit more than that. That's not true. That's not true. No, I mean, it's true that there's nothing specifically in the amendment that states that. That is true. But there's nothing in the amendment that says that, all the other safety precautions are going away either. Because the way they do it is they write this language very vaguely, and they don't define the terms, and then in the courts, they go back and they say, oh, well, underneath this language, all of these fall. That's what they did in Michigan. That's what they did in Ohio. They're doing it in Michigan to compel taxpayers to pay for other women's abortions. And the legal analysis that we have done on this language says it absolutely opens the door to forcing healthcare professionals to either perform the abortion or give up your livelihood and do something else. Because again, they're making abortion a new fundamental right, and then they're saying that no regulation can interfere with that or get in the way. Not a safety precaution, nothing can get in the way of it. So it does open the door to that. Someone could make the argument that because that healthcare professional did not or refused to perform the abortion, that got in the way of her getting the abortion that she wanted at that time, and so that has to fall.
I guess being a lawyer, I read every word. I'm wondering why, if the proponents have ever explained why they didn't limit this fundamental right to pregnant individuals. Because every individual has a fundamental right. I mean, I'm sorry, but I can foresee a boyfriend who gets his girlfriend pregnant saying that he has the right to have an abortion. And then he tells her, coerces her, threatens her, that he's got a constitutional right to do that. What? Nowhere does it say that it's going to be performed on that person. Would they ever explain why? They obviously left out without delivery.
That's a very good point. I don't know, you clearly know better than I do. You're an attorney.
Well, I have no idea why they did. I thought maybe they had offered that tonight.
My comment is the fact that you actually kind of brought it up, but, and there has been an amicus brief filed with our Arizona State Supreme Court. When you make this a fundamental right, and as a civics teacher, you are elevating this right above the right to freedom of conscience, freedom of speech, freedom of association. And that's another reason why this thing is very, very dangerous. Because then you don't, it takes away the fundamental inalienable rights of anybody who disagrees with this proposition to speak against it, have not, if you're a healthcare professional, not get involved with it. You can be coerced because it now becomes an inalienable right. This is not an inalienable right. This should be left to the legislatures so that the people of the state deal with it on a legislative basis, not in a constitution, because then you elevate that right above all other rights. And that amicus brief that has been filed with our Supreme Court is spot on.
Maybe Cindy or the doctor could comment about, it sounds like the number of abortions is going to likely increase because you've got the minors that can now get an abortion without parental consent. And then the other part of the question is, it's all on the taxpayer to pay everything, as it always was and will be with Prop 39. Is that true? Thank you.
Okay, we're gonna split that up into two separate questions because we actually have someone from the Joint Legislative Budget Committee that can speak on the fiscal impact. And so I will leave that part of the question to him, but if the doctor would like to address the first portion.
It's probable that the number of abortions will go up, but what of it?
Well, it's likely because right now it's limited to 15 weeks. This will take it through all 9 months, so that is going to open up more. I think it was either Michigan or Ohio, the argument was, I think it was Michigan, that they argued that they could no longer have those reporting requirements because it was getting in the way and slowing things down, getting in the way of women getting their abortions, so now they're not reporting on them, so we could just not.
Good morning, everyone, or good afternoon, almost good afternoon. My name is Jeff Paulson. I'm an assistant director of the Joint Legislative Budget Committee. We are the nonpartisan budget office for the state legislature. We advise them on fiscal issues, and part of our responsibility statutorily is to write 300-word summaries for your ballot initiative packets. And so if you're looking through the booklet, after the legislative council summary of these initiatives, you'll see a 300-word summary from our office, nonpartisan, just trying to explain an estimate of what the state's fiscal impact would be. So not all taxpayers, but the state budget. And so you'll see that in your booklet, but our estimate for this is that it would not have a direct state impact on the budget. The reason for that is there's existing statutory language that says no state money or local government money can be used to pay for insurance policies that provide this coverage for abortions, with the exceptions allowed by law for those things such as the health and safety of the mother. And so because the clear language of the text of 139 does not touch that statute, that remains in place. And so the budget office's position is this doesn't have a direct fiscal impact, and so would not increase state budget costs directly. And so that's our estimate for this.
What about a patient though who hasn't got insurance and no money?
Okay.
You're interfering with their right.
Answer.
So who pays up when the person does not have insurance? Is sort of outside the scope of our estimate. Someone will pay, obviously, but it would not be the state government because they're prevented from doing that legally.
Can I just say that law that you're exactly talking about, that keeps the state from paying for abortions, will fall under 139, and then the taxpayers will be paying for it. So I understand what you're saying, because you're basing that on the clear language of the amendment. But based on what the amendment will do, and when that falls, then there will be cost to taxpayers.
Yeah, and just to clarify that, so yeah, that may be the case. That would be challenged and it would be decided by the courts. Our offices, we are restricted from speculating on what could happen if there is a lawsuit brought and there's a conflict between a constitutional language versus statutory language. So our office is expressly prohibited from speculating on that, but that's obviously a possibility. Yeah, I'm not running that.
So you mentioned insurance. I personally have had an abortion, and all I remember is cash. Like, nobody asked me about insurance. So I didn't even know that unless you are in danger, the woman is in danger. I think it's more of a cash business. And could you correct me if I'm wrong on that?
That may be the case. I'm not an expert on insurance policies. All I can say is that state law prohibits any state money, so state funding, or local government funding for paying for insurance policies that provide this coverage. And so that may have been the reason why they charge cash, because they want to, state law prohibits insurance policies from covering it if you were a state employee or a local government employee, for example. But I can't speculate on other private insurance policies. They would not be covered by that.
Thank you, Jeff. That's very helpful.
Okay, are there any other questions or comments before I move on to 140? Okay,
Yeah, I just wanted to thank Cindy for coming out here and answering all these questions for all of us. Thank you very much.
I just have one thing that, in a conversation that I was having when I was volunteering for Goes Too Far, had to these really interesting conversations with people, and I had mentioned to someone, I think, and I wanted to verify, I believe though, if a mother is pregnant with a baby, gets to that viability stage, and she's in a car accident and it's a drunk driver, or she's assaulted by someone and they punch her, or they injure her in some way where the baby and or the mother is killed or wounded, that legal charges are filed, and that baby's death is considered murder. Right? Homicide, right?
I know that's the case in many states. I'm not sure. Do you know?
Is that the case?
That is practice here.
Okay, so yes.
So then, what's the difference? And they agree, they'll say, yes, that should be charged as murder. They'll go inside the woman's body. It just seems like so nonsensical. Anyway, it's just, so many points have already been brought up, and I echo everything everyone has said, and it's one of the few things I can think of that hasn't been surfaced, so, anyway.
Tony, I'm just curious if anybody knows how these propositions get numbered. Like, how do they get formatted?
The numbers are sequential based on the time when they're filed. So 100, the ones mean they're constitutional amendments. And so based on, and it's from year to year.
So
They
just
used
one
to
after
start,
another.
correct, they used to start all over again from the beginning each year, but that got very confusing when people would refer to Prop 200. And there were questions, which election year would that be?
So
So now they're sequential from one election cycle to the other.
So it's a coincidence.
Right?
Yeah.
You believe in that kind of thing.
Read Psalms 139 and you'll understand.
It's really a timing thing, you can check it.
Okay. I definitely want to thank everyone for your comments and questions regarding Proposition 139, and thank you, Cindy, for speaking today. Okay, now we are going to move on to Proposition 140.
And I will be going over Proposition 140, Make Elections Fair, Arizona Act. Hold the microphone close. Can you hear me better? Yeah. Okay, perfect. I'm not a professional here, so bear with me. So we'll start with the qualifications and disqualifications of voters. So you'll see the darker blue is currently what's in place, so I'll go over that. The lighter blue is if this proposition passed, this is what would be added to the amendment. So no person shall be entitled to vote at any general election unless such person is a U.S. citizen, is 18 years or over, has state residency, so that's currently in place. Rights of U.S. Citizens to vote, hold office, shall not be denied a bridge on account of sex. And this proposition would also add political party affiliation or non-affiliation. It would also add no person should be denied a ballot for public office, nor be restricted from selecting any candidates for public office based on the person's political party affiliation or non-affiliation. And no person who is adjudicated an incapacitated person shall be qualified to vote, nor shall any person convicted of treason or felony be qualified to vote unless restored to civil rights, and that's currently in the law. Highest number of votes received and voter ranking. So currently, persons receiving the highest number of legal votes shall be declared elected. If Proposition 140 were passed, it would also include does not prohibit the use of voter ranking to determine which person received the highest number of legal votes. Direct primary election law. Legislators shall enact direct primary election that provides for the nomination of candidates for all elective state and county offices and for the U.S. Senator and Representative in Congress. So that would add the state, and you'll see that highlighted. All qualified electors may vote in primary election regardless of the qualified electors or candidates' political party affiliation. All candidates who qualified for election to an office shall be placed on the same ballot for the primary election regardless of the candidate's political party affiliation or non-affiliation. Are those two last ones the new ones? Could you say what's new?
Correct.
So-
Yeah, the light blue will be what would be added if the proposition was added.
Yeah, you need to be clear about that from the last thing you did.
So these are all light blue, so these would all be added if this proposition was to pass. So all candidates for an office, regardless of political party affiliation or non-affiliation, shall have the same signature requirements to qualify for the primary election ballot. Qualified elector may sign a candidate nomination petition without regard to political party affiliation or non-affiliation of the elector or candidate.
does not prohibit political party from endorsing or supporting a candidate. If the law allows a candidate to list the candidate's political party affiliation next to the candidate's name on the ballot must include a statement that the political party affiliation does not indicate a candidate has been nominated or endorsed by the political party, only reflects the candidate's political party registration. And then for any office, one candidate is to be elected. 2 to 5 candidates may advance from the primary election to the general election. These are all new, so all light blue will be new. So this, if the amendment passes, all the light blue would be what would be added to the amendment. For any office, 2 candidates are to be elected. 4 to 7 candidates may advance from the primary election to the general election. For any office, 3 candidates are to be elected. 6 to 8 candidates may advance from the primary election to the general election. Candidates' political party affiliation or non-affiliation cannot be considered when determining the candidates to advance from the primary election to the general election. If the legislator does not enact a law that becomes effective on or before November 1st, 2025, the Secretary of State shall determine the number of candidates for each office who may advance from the primary election to the general election. So these again are all new that would be added if Proposition 140 were to pass. The Secretary of State shall prescribe a process if 3 or more candidates may advance from the primary election to the general election for an office to which 1 candidate will be elected, and the legislator has been prescribed a process by which voter rankings are used to determine which candidate is elected to an office at the general election. Legislation may amend the Secretary of State's determination made, except that the legislator may not modify the Secretary's determination as the number of candidates that may advance less than 6 years after the Secretary's determination is made. It does not restrict qualified electors to change through an initiative or referendum the number of candidates who may advance from the primary election to the general election. Each candidate for offices that have primary elections may appear on the general ballot if the candidate qualifies for the general election through a primary election, fills a vacancy created by the death or withdrawal of a nominated candidate at the primary election. Not more than once every 6 years, legislator may enact legislation changing the number of candidates who may advance from the primary election to the general election. Does not restrict qualified electors to change through an initiative or referendum the number of candidates who may advance from the primary election to the general election. And then not subject to requirements in Article IX, Section 23, expenditures required by initiative or referendum funding source. General elections, so 2 candidates. If 2 candidates may advance to which 1 candidate will be elected, the candidate receiving the majority votes cast is elected. If 3 or more candidates may advance to which 1 candidate will be elected, voter rankings shall be used to determine which candidate is elected for that office. If the majority of votes cast do not rank a single candidate as the voter's first choice preference, then the procedures shall provide for the tabulation of all votes legally casted for that office and take into account voters' rankings of candidates to determine which candidate is elected. And then prohibition of expenditure of public monies for political party elections. So subsection A, except as provided in subsection B, public money shall be spent to administer political party elections, including without limitation, precinct committee officers, presidential preference election, and partisan primary elections to nominate a candidate for public office. Applies to all jurisdictions in the state. Subsection B, political monies may be used to administer presidential preference elections if all persons registered as no party preference or independent or who are registered with a political party that is not qualified for representation on the ballot may vote in the election of any one of the political parties that are qualified for the ballot. If approved by voters, this constitutional amendment shall apply to elections occurring after July 1st, 2026. And then this is the ballot language, so a yes vote shall have the effect of allowing all eligible voters to vote for any primary election candidate, regardless of political or party affiliation, imposing the same signature requirements on all candidates for a given office who wish to appear on the primary ballot, generally prohibiting the use of public funds for political party elections, allowing future law to determine how many candidates advance from the primary election, as well as the process by which candidates are elected to the general election. And if future law provides that 3 or more candidates may advance to the general election for an office to which one candidate will be elected, voter rankings shall be used. And then a no vote shall have the effect of maintaining current requirements related to primary and general election processes. And then do we have the proponent or opponent for 140? Perfect. I'm ready for you when you are.
Proponent or opponent?
Proponent.
Okay, proponent.
Thank you very much. Good afternoon, everybody. My name is Pat DeConcini. I am a 31-year veteran retired from the Air Force. I'm a former federal prosecutor, and I'm also a businessman here in town in the real estate industry. Proposition 140 is what we're talking about, and its main purpose is to establish open primaries. And one thing I'd like to say when we get started, when we're talking about politics and changing elections, we have to remember the cardinal rule of politics, which is politics is the art of the possible. You can't always get everything you want, but if you keep the ball moving in the right direction, then you know you're making progress. So getting rid of partisan primaries. The system today is broken. I think most of us feel a sense of frustration. I know I feel a sense of exhaustion after all of these elections. There's so much bickering, there's so much fighting. There's so many people just at each other's throats. The tribal politics is terrible. We have gridlock, dysfunction. Most of us are aware of that, and we're all kind of wondering what we can do. Is there something that can be done? And we notice that it's just getting worse and worse and worse every year. And one of the reasons that we see that is that we see there's no compromise, right? Politicians aren't compromising like they should be. And there's a reason for that, and that's largely due to the fact that we have partisan primaries. So what does that mean, and why is it important? Well, with partisan primaries, you have approximately 80% of all of the elections and candidates that get elected are elected by only 15% of the population. And that just doesn't make sense to me when you think about it. So how does that work? Well, in 80% of those districts, they're called safe districts. That means it's a district that's so lopsided in favor of one party that the other party never has a chance in the general election. So the only action is in the primary election. It's not in the general election. And the turnout in a primary election is much smaller. It's only about 15% of the population of that district. So what we have essentially in America for 80% of the races is what I like to call the 80-15 rule. We have 80% of all the elections decided by 15% of the people. Now, how many people think that's fair? How many people here think that makes sense? That only 15% of the people are going to decide 80% of the elections. And so it's not really a surprise, right? And these people are more partisan too, right? So on the Democratic side, the 15% that elect their candidates in those gerrymandered districts, they're real partisan. And then same thing on the Republican side. So is it any surprise that when they get to the legislature or when they get to Washington, D.C., boom, it's a collision, right? Because you've got the most partisan extremes on both sides that are trying to now compromise. And guess what? They don't want to compromise because the people that elect them don't want them to compromise. They're disincentivized to compromise. So right now, the system we have disincentivizes compromise. And when you have a system like that, of course, you're going to get the results that we see. We see the gridlock, we see the dysfunction, we see things happening that we never thought would happen in American politics, and I don't know many people that are very happy about the status quo. And it forces elected officials to kowtow to their small partisan base, as opposed to reaching out and talking to everybody in their district, trying to get a broader group of people involved in politics, right? If we had more people involved, we'd have laws that were better for everybody. And that's what Proposition 140 is all about. We're trying to make open primaries so that everyone shows up on the ballot together and everyone can choose whoever they want. And what that's going to do to a candidate that's running for office, let's say I'm a Democrat running, I've got to now appeal to Republicans if I want to win. I've got to ask Republicans, what do you think? And unfortunately, my time's up. I'm just getting started. 4 minutes goes pretty fast. So thank you.
Now we will turn it over. Does anyone have any comments or questions? Yes, sir.
Let's do that.
Okay.
Let's do the opposition first.
Oh, I'm sorry, I'm getting ahead of myself.
Hi, I'm Lisa, and I am a precinct committeeman. I am at the grassroots, but I'm here today to speak against Proposition 140 on behalf of the Arizona Free Enterprise. Proposition 140 is a sprawling measure that adds 15 separate amendments to our state constitution to implement California-style election schemes in Arizona, like ranked choice voting and jungle primaries, that will confuse voters, delay results, and result in voters' ballots being tossed out and not counted. Jungle primaries result in candidates from only one political party appearing on the general election ballot, disenfranchising many voters. Even worse, the drafters of this measure gave one partisan politician, the Secretary of State, the power to decide how many candidates will proceed to the general election up and down the ballot, including his own race. Based on how many candidates the Secretary of State chooses, ranked choice voting might be required, meaning we will have patchwork ballot with different schemes for different races, meaning some candidates will operate under one set of rules and other candidates under a different set. You might have 5 candidates who choose for the governor and rank them from 1 to 5, and then for Secretary of State, there might just be 2 candidates and you vote for 1, all the way up and down the ballot. The drafters of this measure also exempted themselves from the constitutional requirement that a measure that will cost the state money must address where the money will come from. Finally, Proposition 140 is opposed to Republicans, Democrats, and third parties. It's supported only by the special interest who drafted it and who wanted to count 40,000 duplicate signatures and for the courts to put it on the ballot despite the fact it does not have enough legal signatures to qualify. These schemes have been tried in California, which is no less partisan than any other state. On the contrary, they have elections where only a single party measure is to the general election ballot and see more manipulation and gamesmanship of the process. Arizona already has an open primary system that independents get to participate in. They just have to choose which primary, not both. Proposition 140 will make it impossible for third parties to make it to the general election ballot. It will confuse voters. It will lead to long lines. The simple truth is that it was poorly drafted and tried too much, hoping to trick voters into accepting all 15 amendments by only discussing one. Proposition 140 is wrong for Arizona.
Now we can move on. Does anyone have any comments? Yes, I can move red.
For the Pro 140, I'd like to understand how it is different than than the elections that are currently occurring in California? I try to read it and understand it, I've watched videos on it, there's partial credits, and it's incredibly confusing. So how is it different than California elections?
You know, when you try to defeat a proposition, what you do is try to throw up a bunch of stuff against the wall, make it confusing, people don't go. This proposition is really very simple.
No.
What it's not about, what it's not about is ranked choice voting. It's not about a top 2 jumbo primary. It's about the primary elections. Currently, if you're independent, and independents make up 34% of the total voters in Arizona, but they're not treated equally when you go to the ballot. If you're an independent, you have to request a ballot. Most don't. Most don't choose to participate. If you're a candidate, you need 6 times the number of signatures that a Republican or Democrat would need to get on the ballot. So there are no independents in the legislature. I don't think there's ever been an independent in the legislature. So all we're doing is we're giving independents and all voters the same rights in the primary election. The rest of it is the opposition to it is just confusing. They're just trying to confuse the issue. You have to have a system after the primary, so we put guardrails on what the legislature can do. But we're actually taking power away from the legislature in terms of what they can do in the general election. This is about the primary elections.
And then you have your hand up, I'll come to you.
All right.
Yes. Yes, but it's not going to be like a rebuttal back and forth, because I really want to make sure that everyone that has a question or comment can answer.
Right, I just want to address how the independents are involved in the voting process. So if you're an independent and you do mail-in ballot, for example, 3 months or so before any election, a postcard is sent to your home, and you are asked, what ballot do you want mailed to you when the primary election starts? So if you choose Republican, you'll get the Republican ballot. If you choose Democrat, you'll get the Democrat ballot. All you have to do as an independent is choose which one you want, and you are notified plenty of time before the election, or if you go and show up at the polls on election day, all you do is show your ID, and you tell the poll worker if you would like to have the Republican or the Democrat ballot. So independents are not shut out of the process at all. They just are different, so they have an extra step to take. Thank you.
I'll take your comment first, and then I will head up to you shortly, ma'am.
I think the opposition voiced one of my concerns was primarily, I look at the open primaries and stuff in California, and I see all the Democrats are running for that particular office. And any one of the different kind of political point or view are shut out. They're shut out. And it's, to me, that was a concern I had. If you need 15 amendments to write something like this, then you're not dealing with just the one thing of trying to address a particular thing for independence. That's way overboard, and it's too much messing around with the political system, in my humble opinion.
And I will come to you.
I have a question. If this was just about the primaries, and it's not about ranked choice voting, how come ranked choice voting is in? Why does it include it?
Thanks for that question. I'm Sarah Smallhouse. I'm chairing the Proposition 140 campaign. The reason why we have ranked choice voting in there is to ensure a majority of voters are in support of the ultimate winner. And the reason for allowing more than 2 people to go to the general election is to give voters more choice. Independents are an important group of people. They're roughly equal to Republicans in Arizona now. They're the fastest growing group of registered voters in the state. And with a top 2 system, which is we have now, a Republican and a Democrat, it is possible with open primaries, you would have 2 people from the same party on the ticket, which is, you know, objectionable by a lot of people. However, in those districts where you get two people from the same party advancing as the top two vote getters, you're probably in one of those 80% districts where one party or the other dominates. And so the question is your choice better if you have a choice between the dominant party person who will win and the other person who may be a good philosophical standard bearer but doesn't have a chance in that district, or a choice between a more moderate and a more extreme person from the dominant party. We think it gives voters more choice, even if there's two people from the same party on the general election ballot, to choose how they're governed. As far as California goes, California is a really different state than Arizona. I think their voter registration is almost 2/3 Democrat. So our supporters for this measure, this has been fully funded inside Arizona. There's no copying legislation from any other state. This is a homegrown thing, and it's about aligning the incentives of candidates and politicians with the general electorate. The Center for the Future of Arizona has done considerable research showing that people are not happy with the way our state is governed. And our representatives are not talking about the issues that voters care most about. This is an attempt to address that.
I saw your hand first.
So in your response, you mentioned that it's likely or it can happen where multiple candidates from the same party get to the general. And you also pointed out, one of the other speakers pointed out, that during primaries only 15 or 20% vote, and that's also a true statement. The point that you kind of slid over, though, is during the general election, when most people are paying attention, they're only going to hear in these districts that are predominantly biased one way or the other, they're only going to hear from one point of view. And so this system destroys the opportunity for voters to hear alternative points of view when they're most likely to be paying attention. And so that's what's wrong with open primaries, because they will smother opposing points of view from ever getting to the general when actually most of us are listening.
Was that, there was a comment, there's no response. Was that a question?
Just a comment.
Just a comment, so, okay.
I have a comment. This is not a homegrown initiative. This is being promoted all over the country by big money and out-of-state people. It is not about open primaries and ranked choice voting. It's about throwing our entire government into chaos. When we don't have a party system, we have no way of determining committees, leadership, how the legislature is going to function. We'll be confronted with something like a coalition government that we know nothing about, and it's going to have to be instituted anew. I think this is a terrible idea. It's going to be, if the legislature doesn't decide how it's going to be run, it goes straight to the Secretary of State, who's going to determine our entire election process. One person is going to determine our entire election process. We do not want this. This is a disaster. I've got lots of comments about it, but please vote no.
Okay, let me get to others as we've actually heard from you. Are there any other comments before I go back to others that may have already spoken? Are there any other comments or questions?
I have one question for the proponent. So he said he claimed that this proposition will get rid of gridlock and partisanship. So do you really expect that candidates' political ideologies will just disappear? Will all become central moderate points of view? We won't have the far left, more liberal point of view, and the far right, more conservative point of view, but that will just disappear if we have all of these candidates to choose from. And plus, it's deceptive, and they don't have to show their party that they represent. So you don't know their point of view necessarily on the ballot. It's up to them if they want to declare a Republican or a Democrat. So how do you explain that?
Yeah, thank you. I think the best way to explain it, you're right, people aren't just gonna change and all become moderates. I'm not suggesting that. But what this will do, it will empower people that are moderate. Okay, that's what it really does. It's gonna disempower the far left, and it's gonna disempower the far right. And it's gonna empower the people that are in the middle. And when you do that, what you're gonna have is you're gonna have more compromise. You're gonna have more nice people. They're not gonna be as mean to each other, right? And they're gonna need to. Remember, they wanna get elected, right? So if you wanna get elected, you have to appeal to a broader base, right? When you have to appeal to a broader base, you can't be stuck over there on your far left side, right? If I'm a far left guy, I'm not gonna get elected. And so if you're a far right person, you should like that because you don't want those far lefties. You'd rather deal with someone closer to the middle, someone that you can make a deal with, someone that you can work with, as opposed to having these tribes that don't ever talk to each other. Okay, and then to the other point that was made, let's look what happened up in Alaska, where they did this, and they did ranked choice voting up in Alaska. Well, for the first time, they had a Democrat that got elected into that one House seat. Now I know for this audience, because I can tell who I'm talking to, that doesn't sound like a good thing to have a Democrat elected into that Republican seat that's been Republican for 50 years. But guess what that woman did that was elected to that congressional seat? The first thing she did was she appointed the former chief of staff from the longstanding Republican congressman. She made the old chief of staff for the Republican guy that had been there forever, her chief of staff. Now, why would she do that as a Democrat? Why would she make the most important person on her staff a Republican that's known in Alaska as being a hardcore conservative? She did that because she knew to get reelected, she needs Republicans, right? So she reached across the aisle to show, I'm not a crazy liberal. I put this guy in. You guys can talk to me. I'm going to listen to you. And that's what will happen here in Arizona. We'll have more people talking to the other side, which is what we need.
Because I haven't heard anything for either one, so you go.
I was wondering if there was a way, if there are any issues with an election, if there's a way to audit the election with 140 after the fact. Can you audit an election?
Sure, you can audit the same way you audit the current elections. They can be audited, the same rules apply. Again, this is not ranked choice voting. This is not a jungle primary. This is about open, nonpartisan primaries where everybody's treated equal. And contrary to some of the statements that were made, this is not instigated by people out of state. Every dime that's been raised so far, almost every dime, has come from in-state people. It is. And it is, well, our finances are online and you can look at it now. The other thing I mentioned is that this is not something that's new. We've had this system in Arizona for almost 100 years. Every city in the state, except the city of Tucson, currently has nonpartisan primaries. And you know what? The people think much more highly of their local elected officials than they do their state or federal officials. And that's one of the reasons why. And if you're a partisan in the city of Tucson, this is going to apply to the extent that you have to have a nonpartisan primary. So, you know, what that means is in the last election, instead of just having the Democratic Party determine every single city council seat, you now have an opportunity for an independent or a moderate Democrat to run in the general election and get elected. You don't have that opportunity now because it's run by the machine. So what we're doing is we're creating an opportunity for everybody to be treated the same. That's all this initiative does. Every voter, every candidate is treated the same in the primary election. That's not a bad thing.
Can I answer the question?
Oh. And then I'll come right back. Okay. Let's remain respectful, everybody. That is the main goal, because we're all adults here. For the main part, we want to remain respectful, regardless if you agree or not. You can agree to be respectful, because that's what we need in here, respect.
So, ma'am, to answer your question about, I think it was about how you tabulate votes when we use ranked choice voting. So let me give you an example of how ranked choice voting is going to work. Let's say you have 5 candidates. Yes, she's asking how it's tabulated, so I'm going to tell her how it's tabulated. Oh, audited, but you have to understand how it works to understand if it can be audited. So, thank you. So say you have 5 candidates on the ballot. Each voter is going to be required to rank all 5 candidates. So what will happen is, if you only rank 3 candidates, okay, but if you're gonna rank all 5, you have to study all 5 of those candidates. So what the tabulation will do is it will take into account who got the most number 1, who got the most number 2, who got most number 3, who got the most number 4, and number 5. So whoever gets the least amount of votes, whoever got the 5th most, that person is now eliminated. If none of the 5 got 50% plus 1 of the total votes. In our elections today, what happens? Of those 5 candidates, whoever gets the most votes win. But with ranked choice voting, you have to get 50% plus 1. So let's say all 5, none of those got 50% plus 1. So the one who got 5th place gets eliminated. So ma'am, if your candidate got eliminated and you don't have anybody else on your ballot is now tossed aside. So then you go to another round of tabulation, 1 through 4. The 4 candidates are left, and so on. So when you ask, how do you audit that? I don't know, because we don't get to see the software that does that counting. And one more thing that we just learned about this, let's just say it's a state race and for governor. And you know, every county does their tabulation. Well, that won't happen anymore. Payment County will now have to take the results for the governor race, send it up to the state, and they will then do the tabulation for that race from all the counties. So here you got files going all over the place for election time. How long is it going to take to actually tabulate, and let alone be able to audit what happened? Thank you for the question.
Now, really quickly, when there is a question asked, let's make sure we are specifically answering that question and not straying, because we want to make sure that the questions that are being asked are asked. And if there's comments, that's okay, but specifically answer the questions that are being asked.
I just wanted to address a few issues just to set the facts straight. One, as far as funding for this ballot measure or any other ballot measure, please check out the Secretary of State's website. Spotlight is the name of the campaign finance disclosure section of the website. You can see everything about who funded these initiatives. Another thing, this ballot measure specifically does not require ranked choice voting. In fact, it will be up to the legislature to make that decision. As far as how long the legislature has, they have 1 year to create the system within the parameters set forth in the initiative. And lastly, the question was about auditing. Nothing in this ballot measure affects auditing, the post-election audits. Thank you.
I'm an independent, but I think my main complaint about this initiative and why I cannot vote for it, there are a few things I understand about independent candidates. I think anybody who runs for an office should have the same number of signatures to get on the ballot, okay? But the problem with this initiative, there are so many aspects to this initiative. Some are good and some are not good. This is not just about what happens in the primaries. So I think it should have been limited when it was written so that people could focus on exactly what they're talking about. Not every single one of these little things, because what ends up happening is, and unfortunately, as a civics teacher, if you think that our voters are informed, I'm sorry to tell you, they are not. And they are not going to want to weed through all of the information. I hate to say that, but I know for a fact that that is true. They want something simple, soundbite, give it to me straight. So all they're going to see is this is just about making the primaries fair, when that is not what is this initiative is about. So because it is so involved with all of these items, it should not be voted for. It needs to be limited so that our voters will understand really what is going on. Because many of them out there who are trying to understand this, they do not understand it. So I encourage people to vote against it because it's got too much stuff in it. Some of it which is, like I said, good, but some of it which is not. And you're not going to get your voter to go and look and find out about every aspect. They're going to look at the one little blip that's on their ballot. Oh yeah, I think I want that, you know? And that's just the facts of life. And so consequently, it should be voted against.
So you made an earlier statement that a lot of people are dissatisfied with politics and the party system. I'd like to put this as a question to the proponent side. 65% of us are registered with a political party, whether it's Democrats, Republicans, Libertarians, and whoever else. What is your argument that a minority, 30%, 35% roughly, should tell the majority, which are happy with their political parties, that they're not allowed to be involved or allowed to use their political parties as their vehicle for expressing their political opinions? Thank you.
Yeah, thank you for that question. There's nothing in this initiative that prohibits the political party from having its own primary. It's just they can't be funded by the public. Yeah. So and you know, in terms of the political parties, I think the political parties do a lot of good. The Democratic Party does a lot of good. The Republican Party does a lot of good. This is not intended to destroy the political parties. What it's intended to do is strengthen them. Because right now, if you're a Democrat, all you have to do is appeal to the extreme left of your party to get elected. And that becomes your entire constituency. You don't talk to anybody else in your district. And if you're a Republican, you appeal just to the 15% on the extreme right of your party. You don't talk to anybody else in your district. And those elected officials then get to Washington or they get to Phoenix and they won't compromise with each other. They won't talk to each other. And consequently, we don't have legislation that reflects what the people want. The Center for the Public Good of Arizona, Center for the Future of Arizona did polls, and it found that on almost every major issue, there was consensus as to what should be done. Education, immigration, infrastructure, you go right down the list. But none of it ever gets done because of the extreme polarization. So this fixes that. And to your comment over here, it's so complicated. I apologize if I went too long.
It's just a comment, but I respect what you're saying, that you feel like the politicians will have to appeal to a broader base. However, in my experience, politicians are often not truthful. And so they may appeal to the broader base during nominations, during voting, but then when they get in office, there is no guarantee that they're going to stick to what they said during their campaigning. So I think we're still going to potentially be at the same gridlock.
How many jurisdictions currently have ranked choice voting, and how many, and has it been repealed?
You know, I don't know in terms of the actual number. I think there are There are like 29 or 30 cities, major cities that have ranked choice voting. But again, this proposition is not about ranked choice voting. It does not require ranked choice voting. It enables ranked choice voting. That's not allowed currently. But there's one state currently, Alaska, that has ranked choice voting. It's on a ballot initiative in the state of Nevada, and I think there are 4 other states that are holding those elections that it could become part of their state statutes. So currently, there's just one state, but there's 29 or 30 major cities that have ranked choice voting. But again, we're not requiring ranked choice voting. We're not requiring top 2. This is about open primaries, and this is about fairness.
So as of January of 2024, over 85 jurisdictions nationwide have implemented and then repealed ranked choice voting. Alaska is expected to repeal ranked choice voting this November.
I just ask, why is it so complicated?
It's not. It's not complicated. There's a question over here, which I think the comment was a very good one, that she's an independent, she's in favor of having everybody play by the same set of rules. So you have independents, they get the same right to vote, they have to get the same number of signatures to get on the ballot. But in order to do that, you can't just say that's the rule and we're going to have open primaries, because it affects what happens down the road. So you have to make these other changes so that change works. And that's the reason. It sounds complicated, but the legislature could do all these things now anyway. The only thing it couldn't do is ranked choice voting. But it could create a top 2 primary. It could create an open primary. And they won't do it because the incumbents like the current system. It helps them get elected, and they don't have to work at it. They don't have to talk to the entire constituency. So it's never going to happen currently, but it could. So all we're doing is putting guardrails on what the legislature can do in the general election. But the focus of this initiative and the sole purpose of it is to treat everyone fairly in the primary, to have open primaries where every candidate and every voter is treated the same.
You mentioned that it wasn't ranked choice voting, but you used Alaska as the example. I'm curious though, if it's far left or far right in the district, and you want everyone to come to the middle, you're now removing that possibility. So really it's up to the people in that area to make the choice. You're just muddying the water. Like this lady said earlier, basically we've got a situation where people listen to sound bites and short snippets. It's almost like the judge situation on the ballots. Does everybody know the judges on the ballots?
Was that a question?
Yeah, that's a question.
If the district is a district that's far right, they will send 2 far right people to the general election, and those people will be able to choose who they want. If it's far left district, same thing. Our proposition is that whoever is in that district gets 1 vote in the primary, whoever the top vote getters are in the primary, advance to the general. It may be a split Republican Democrat, could be 2 Democrats, could be an independent and a Democrat. Alaska is not our model because they prescribed ranked choice voting. Well, somebody said it, I didn't say it. It's an allowable outcome with this. We have done a lot of research and young people really like it. You know, what we're doing is saying open primaries should be part of the Constitution, and the general election should be something that can change and evolve with Arizona's preferences, including ranked choice voting if they want it. And with the open primary, what you will get from each district is the 2 most favored candidates in that district, regardless of what their party is. So it will not deprive people of their choice. if you get two people from the same party, it is true that it's likely one of them will be more extreme than the other. So there is a certain choice there. But it's about allowing all voters to express themselves. And I will just say that independents tend to turn out more in the primary with open primaries.
I just want to talk a minute about the ideology in our party platforms. You know, we are Republicans or Democrats because we like the ideology, we like the platform. We feel that these people are representing what we want in our government and our country. What happens with this ranked choice voting is that people end up with their second or third or fourth choice, and it doesn't represent any ideology at all. The person that's going to run third or fourth choice is going to have no ideology. He's going to just be there so that he's not the extremist, okay? So we end up with candidates that nobody ever really wanted. They're people who have no ideology and don't have any platform, and it makes it easier for big money and lobbyists to use them as puppets. This is a real reaction against our grassroots that has been rising up and determined to take over our government and have a government that we want, not that's being controlled by who knows who. No,
I'd just like to say that I am an independent voter, and I also have a background in psychology, so I know that everyone has an ideology. Whether they call it the name of a political party or not, they have an ideology. And I've always been frustrated as an independent that I don't have the choices I want. So the fact that this is trying to empower those different voices to be able to get on the ballot, I like that. I really like that. I'm interested in the concept of ranked choice voting because of that, and have been for a long time. I do have some questions about, well, let me first say, I understand that there's been an attempt to kind of, clarify certain aspects of how this would be, and that's why there's so much detail added to it. And a couple of questions I have for the proponents are, why was the choice made for so many decisions to be in the hands of the Secretary of State? What are some of the intentions with the details that have been
The decision is the legislature's decision. The Secretary of State will never be involved if they do their job.
What if the governor vetoes their job?
If they don't do their job, or the governor vetoes, the Secretary of State will make a determination. That is the highest ranking election official in our state. The reason why that was decided was to avoid lengthy and expensive and drawn out court battles. We wanted to have a backstop solution. We would like to think our representatives will act in our long-term best interest and make a decision in the legislature.
So just to point it out, this governor has vetoed 200, 300 bills coming out of the legislature. This thing has to be done within a year. And then if they don't pass something that the governor, who has already basically rejected all of their bills, she's going to veto it, and it's going to go to Fontes. So it basically takes a path directly to a very radical Secretary of State. You guys need to talk about that honestly. That was a statement and a request.
Request for a comment?
No, not a comment. I've heard a lot of comments so far.
I was about to make that comment.
basically you're empowering one person, the governor, to determine whether this gets made, the decisions get made by the legislature or by the Secretary of State's office.
But it's a question about the process.
And the timetable is such that it will be the current governor and the current Secretary of State.
You know what's interesting is that the current governor opposes this initiative, which she's an incumbent. And most of the legislature opposes this initiative because they're incumbents. Incumbents don't like this because it forces them to run in elections where they have to deal with everyone. But to your point, we wanted to avoid a situation where the legislature just decides not to make a decision, right? So the initiative passes, it goes to the legislature determines whether it's 2, 3, 4, or 5 that go up to the general election. The legislature says, we can't decide. So we just have to retain the current system. So that's why we had to have a mechanism to break the tie. And as Sarah said, the tie is broken by the highest ranking elected official in the state of Arizona, who's the Secretary of State. That can change from election to election. So not necessarily Fontes. It is this time, might not be next time.
I will take one more question or comment because we're gonna have to wrap it up. And let me just make sure that is there anyone else who hasn't spoken that wants to speak politically? Okay.
I would just comment that this supposedly allows independents to participate more broadly in the primary elections, but I see it has the inevitable effect of denying independents choices at the general election, because you're going to end up with candidates at the general election for each office. There will be candidates from the same party, and there will be no other party for the independents to choose from.
Thank you. Okay, really quickly, some reminders for you. The voter registration deadline is October 7th, 2024 at 11:59 p.m. Of course, you can register to vote at Service Arizona, as well as if you feel free to go to our website at azsos.gov, arizona.vote. In-person early voting starts October 9th, and it goes through November 1st at 7 p.m. Of course, we have election day, which is November 5th, 2024. Don't forget, polls open at 6 a.m. and they close at 7 p.m.
Are we going to hear the cost of implementing this from the financial guy?
He would only speak if there was a question.
I have a question. What's this going to cost?
Okay. We have to keep it really brief because we have to be out of here at 1 o'clock.
Thank you for the question. So for anyone who wasn't here in the prior discussion, my name is Jeff Paulson, Assistant Director of the Arizona Joint Legislative Budget Committee, nonpartisan office that works with the legislature on fiscal matters, including the budget. And so, like I said, in these packets that you've received, in your ballot packet, you'll have a 300-word summary of our estimate of the fiscal impact of these propositions that are voter initiatives. So you won't see 300-word summaries for all of the legislatively referred initiatives, although we do those, and you can find those on our website at azjlbc.gov. So to your question on this one, so the state currently pays the cost of distributing sample ballots to certain registered voters. Local governments otherwise cover the cost of administering the election. So Pima County, Maricopa County. If you live in Pima County, your ballot's coming from the Pima County Pima County government. So the proposition could affect state costs in a few ways. Increasing the number of candidates that appear on the general election ballot. Changing the length of both sample and election ballots. If there's more people on them, the length of the ballots could be longer. The cost there would be more paper, potentially larger mailing costs with stamps and such. And then increasing the number of voters receiving a primary ballot. As we talked about, this would open up the primary ballots to everybody. So independents who currently do not, or those with no party preference who currently do not elect to receive a ballot from either the Republican primary or Democratic primary would then receive a ballot. And so more people would receive ballots. So there could be costs associated with those. The proposition also generally prohibits the use of public monies, so state monies, to administer political party elections. The state currently pays the cost of the political party's presidential preference elections, so that's a state cost every 4 years. Non-affiliated voters, so independents, no party preference, cannot participate in these elections. So what this would do would say, if they, I'm sorry? They can't participate in the PPE, the presidential preference election. Primaries, you're correct, but presidential preference elections are something slightly different. And so yes, it can be confusing because we think of it as the same thing. This would say if the parties do not allow independents, no party preference, to participate in those, then they have to pay for it themselves. If they do allow people to expand, then the state would then share in some of that cost. And so there are a lot of moving pieces here, as we discussed. It's up to the legislature. They have next legislative session to, assuming this passes, the legislature could act. We don't know how they would exactly design the system. If they don't act, as we heard before, the Secretary of State could make a decision on how this would be implemented. And so, because the implementing details are subject to further action by the legislature or the Secretary of State, it's really difficult for us to determine any cost in advance. There could be some increased costs associated with primary elections. There could be some savings in the event that the state no longer funds the presidential primary or presidential preference elections. And so the dynamic there would just be hard to know what the net effect of any changes would be. And so we're unable to come up with a concrete fiscal impact for this proposition.
Would the elections have to be centralized somehow from taken away from the counties and put in some central state election center?
So that's outside the scope of the fiscal impact. I would defer to some of our lawyers here who would know the details of that, and Colleen.
And then we're gonna have to wrap it up. I'm so sorry, we've been asking questions all day, so we have to be out of here, so I'm gonna wrap it up after this.
And nothing would change as far as how the administration of the election works. It would not be centralized.
Okay, I definitely want to thank you, Patrick, thank you, Lisa, today.